Good afternoon, everyone. My name is Jamal Zavali. I'm a student at Center for Public Legal Education Alberta, or CPLEA for short. Welcome to our 1 hour long webinar this afternoon, Wills Uncovered. I will introduce our panelists in just a few moments. Before that, Jessica from CPLEA will be monitoring the chat during the presentation and posting some things in the chat as we move along. Before we move on, CP respectfully acknowledges that we are located across Treaty 4, 6, 7, 8, and 10 territories, and respects the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our vibrant community. Also, a quick disclaimer, this presentation contains legal information only and is not legal advice. We'd like to thank our funders, the Alberta Law Foundation, the Department of Justice Canada, and the Alberta Real Estate Foundation for making our webinar series possible. A few housekeeping items. First, we will be recording the webinar for our on-demand viewing on the CPLEA website YouTube channel. Second, we'll answer questions at the end, but please submit them at any time during the webinar. Third, please fill out our short survey when you exit our webinar at the end of the day. So who or what is CPLEA? CPLEA is the Center for Public Legal Education of Alberta, and our goal is to make the law understandable for Albertans. We're a nonprofit organization serving all of Alberta. We provide legal information and education through our various booklets, tip sheets, videos, webinars, websites, and more. Our goal is to make the law available and understandable to empower Albertans to use the law. And here's a snapshot of our website. We cover a variety of legal topics, and several of our resources have been translated to French. So today we have Sherry Simons as our panelist. Thank you, Sherry, for joining us today. Sherry went to law school at the University of Alberta and has been practicing law since 2014. She is joined with an LLP in May of 2023 as a solicitor in the firm's Wills and Estates Group. She assists clients across Alberta with estate planning, estate administration, real estate, and corporate and commercial matters. In her free time, Sherry enjoys traveling, baking, and hiking with her family and 2 dogs. Now I'd like to pass it over to Sherry for a brief introduction.
First, I'd like to thank everyone for joining us today. As mentioned, my name is Sherry. I work at a firm in Edmonton, and I practice predominantly in Wills and Estates. So I've been doing Wills and Estates work for close to like 10 years now. I've been a practicing lawyer since 2014. And, I'm here to answer some top questions regarding estate planning, estate administration, and let you know more about the wills process.
Thank you, Sherry. And yeah, we'll go into our questions here. So our first question of the day, what is a will?
Okay, so a will. A will is a legal document that outlines how you want to distribute your property when you pass away. The document also appoints somebody known as your personal representative to manage your estate. So they're the persons in charge of making sure that the terms in your will are fulfilled.
Perfect, thank you. So why do I need a will and when should I make a will?
Yeah, so it is generally important for everybody to have a will. Unfortunately, everybody will eventually pass away. So it's important to have a document that outlines, what you want done with your property. You want to make sure that certain gifts are made to people, make sure certain people are taken care of in your life, and also to appoint somebody to manage and make those decisions for you. And when should you make one? I mean, I always tell my, people that I talk to that the best time to make a will is pretty much now. It's a good time to make, decisions now, prior to any major travel plans or, surgeries you might have coming up. Make your estate plan as soon as you can while you are clear-minded and have time to think about your different options and make those decisions. So pretty much the time is right now.
So being proactive with your wills.
Absolutely, yeah. You don't want to wait until, you're really sick and, your family's scrambling to help you put something together. Do it now while you have, the chance and you're clear-headed and you can make those decisions for yourself.
Mhm. Thank you for that. So who inherits my profit if I don't have a will? What happens if I wasn't proactive and what happens then?
Yeah. Yeah, so that's a very good question. So contrary to a lot of misconceptions, your property doesn't just automatically go to the government. So if you don't have a will, we do have laws in place that kind of act as a default under a law called the Wills and Succession Act. So this document outlines if you don't have a will, where is your property supposed to go to? So it really just depends on individual circumstances. So it depends if you have kids or no kids. So, I mean, generally, if you have kids and you're with a spouse or partner and, your kids are with that spouse and partner, things will go to your spouse or partner first. If you don't have a spouse or partner, then your property will be divided equally between your children. So again, there's kind of like, you gotta kind of look at it technically. So spouse or partner has first priority generally, then it would be your children. If you don't have children, it'd be grandchildren. If there's no grandchildren, we start looking backwards to parents, and then if there's no surviving parents, siblings, and then nieces and nephews. So the law does set out, there is a blueprint there as to who gets your property if you don't have a will setting out where you want your property to go.
So what are the legal requirements for a will to be valid in Alberta?
Yeah. So under Alberta rules, there's basically three different kinds of wills that you can have. So the first is known as a formal will. So this is one that is like typed up or in some kind of writing, and it's signed by the person making the will in the presence and along with two witnesses. So that's called a formal will. So that's valid in Alberta. You can also have something that's known as a holograph will. So this is a will that is made entirely in the person's own handwriting and then they sign it. So that kind of document would also be valid. We also do have a special consideration for military personnel who are on active service. So they're allowed to sign a will without the requirement of witnesses or handwriting. So if they're on active service, the rules are a little bit more relaxed for them. So as long as you meet one of those kind of three requirements for a valid will, then your document is good to go.
And so within those three, is my will valid outside of Alberta? How does that work?
Yeah, so generally, like if you're an Alberta resident, you're making a will here. Generally within Canada, your will be recognized in other jurisdictions. But it's important to know that provinces across Canada will have different rules regarding wills and the probate process. So if you move to a different province, it's important to update it. So generally Canada will have, similar rules across the province, across the different provinces, but it's important to always check if you do move. Outside of Canada, though, it's, very difficult to say if your Alberta made will would be valid. So if you do move outside of Alberta or if you have property outside of, the country of Canada, it's always good to check with a professional in that jurisdiction to see what the requirements are. They can take a look at your Alberta will and give you advice, if you need to make a new will or what the case is, but it's good to check.
Thank you. And so how can I make a will? You did touch up on this, but
Yeah. So again, there are the three kinds of wills. So if you're doing a handwritten will all in your own handwriting, you can certainly do that yourself. If you want to make a formal will, it can be typed up. You're going to need to have, two witnesses present when you sign it. One of the witnesses also has to meet with the commissioner to sign a legal document known as an affidavit of witness. This is just a document that is sworn or affirmed by one of your witnesses, just saying that, yep, I saw this person sign their will on this date. And it kind of outlines just some facts about the date of signing. So, when you're making those kind of wills, You can do it on your own. I mean, there's will kits that are available out there. There are some services online where you can, sign up and do a will and have it prepared for you online by answering some questions. Of course, there's also, you can go to a legal professional. Like I have been doing wills and estates for close to 10 years now. And, the process when you come to see a lawyer is we look at all of your property, talk about how you want your property to just be distributed, look at different options. We could provide you with advice and that kind of thing. So there are different ways that you can approach it. Of course, coming to a legal professional, you're going to get the benefit of our knowledge. We know what judges look for in the probate process. So we try to help you to prevent any problems that can arise if you're trying to do it yourself and you're not meeting certain requirements. So yeah, so those would be the different ways that you can make a will.
Mhm. Thank you. So you did also touch upon this, but can I register my will somewhere else?
Yeah, so again, because each province in Canada has different rules, some provinces will have central registries where you can record the making of a will, and some don't. So in Alberta, we don't have a centralized system for recording and tracking wills. So if you do make a will here, it's important to let your, proposed personal representatives know where your will is stored. A lot of law firms will store your original will for you. In there, we have a fireproof vault, for example, here, typically at no charge. So you can store your original will with your law office if that's something that they, have as a service. So yeah, there's no central registry in Alberta where you can. And I do know that there is some companies that are trying to set up kind of private registry options, but right now there's no central government regulated registry. Other provinces might have a registry. BC does have one that is operated by the government. And so, lawyers in BC can register there, but here in Alberta, we don't have that option. So sometimes it
Mhm.
can be tricky to track where a will is.
Mhm. So what obligation do I have towards my spouse or partner in my will?
Yeah. So when you're making a will, you do need to make sure that you're making, decent and proper support provisions for anybody that is, your legal spouse or an adult interdependent partner. So in your will, you do have to be mindful when you're making and disposing of your property, if your partner or spouse is, supported. If they don't, if all of your property is not going to your spouse or partner, then your partner would have the legal right to make a claim against your estate for more support if the current support that you made in your will is not adequate for them to properly support themselves. So yeah, it's definitely something you have to consider, and there's other people as well that you do need to consider when making your will. Certain people, if they're dependent on you, can make those kind of claims if they're not properly supported. So when clients come to see me, that's always something that we will discuss.
Mhm. So how do I deal with digital assets in my will?
Yeah. So digital assets, it's, we're in the day of digital technology and, data. So it's important to make sure that your will contains some kind of definition about, your digital assets and what that would, encompass. And disposing of your digital assets, because your digital assets are still property that belong to you. So it should be addressed in your will. So, when I'm working with clients, I kind of ask if there's anything digitally that's very important, just to make sure if they have something that's important, it's going to the persons that they want it to go to. So digital assets can be, social media accounts, any, documents or data stored on your computer, laptops, cell phones. So that could be a lot of photos as well. So any of those kind of documents, photos, and accounts. So we always to just, discuss that. And if there's anything really special you want given to somebody, we will do that. Otherwise, all of those digital assets, we want to make sure that it forms part of the residue of your estate.
Mhm. So then how do I deal with a business in my will?
Yeah. So businesses can be a little bit more tricky and complicated to deal with. So if you're a shareholder in a business, you own shares. In your will, generally, you would have the right to gift those shares to somebody. So you can give them to somebody specific, or they can form part of the residue of your estate. However, we do have to be careful because sometimes businesses will have certain restrictions as to who's allowed to take over or buy shares or inherit shares. So when we're looking at any corporate assets, we also want to look at the corporate documents just to see if there's any of those kind of restrictions there. So it can be a little bit more complicated, and that's something that I look for when I'm dealing with clients who do own shares in the business.
So how do I deal with property in another province or country in my will?
Yeah, so this is very important because I mean it can be common for people to own property in other provinces or even outside of Canada. So like I said, every province will have different rules. In Canada, if you're drafting your will in Alberta, generally it will be valid across the country. But if you do have real property somewhere in a different province, it's good to just get your Alberta will checked just to make sure it's meeting their requirements. Um, if you have property outside of Canada, again, your will may or may not meet the requirements. There could be, other, problems that arise if you have an Alberta-based will and, and you're trying to rely on it in a different country. So what I always do tell my clients is, we'll make your will here, but if you have property outside of the country, have it reviewed. And there's a good chance that a lawyer in that, outside jurisdiction will tell you, you know what, we need to make a will in this jurisdiction, in this foreign country, to address the property that you own here. So sometimes you're left in a case where you will have two different wills and you might need them. So that's always something that I look at with my clients. And we just want to make sure that if there are two different wills, that they're not canceling each other out and that they're working together to make sure that all of your property is properly disposed of.
Mhm. But just to add on to that, you can still put the property that's outside of Canada or another country in your will.
You can, but again, the recommendation is you need to get this checked by a lawyer in that jurisdiction. Because
Mm,
I cannot make any guarantees that it'll meet the requirements of that foreign jurisdiction, that different country. So you do have to get it checked because I like at that point I can't guarantee that. And a lot of countries will have completely different rules from Canada. So it's always good, like, yeah, get it checked because it might not be valid or binding in that foreign country.
makes sense. Thank you. So yeah, can I leave my property to someone who lives outside of Alberta?
Yeah, generally any, beneficiary who's, residing in Canada, like no problem. When you are leaving specific property to people that live outside of Canada, then it can cause problems because sometimes there can be, inheritance restrictions or prohibitions if you're trying to transfer property or farmland to them. So it really depends on the asset. But generally, if you're just leaving general residue to somebody outside of Alberta, that's not going to cause a problem.
Perfect. What are the rules for making a will about property on First Nations reserve?
Yeah. So First Nations reserves, so when I'm dealing with First Nation clients, there can be different laws that apply to them, and it will depend on their particular circumstance. So I will look at things, if they have, status registration, where are they currently living? Are they on reserve or off reserve? So those are some things that I need to check with them. So if they're part of a particular First Nation band, I want to kind of look at if they have any possession or occupation rights to any First Nation or Crown land. Have they made any improvements to those kind of lands? And all bands, First Nation bands, will have different property policies for their band. So we kind of look at the policies and see what, inheritance rights would be. So it's definitely something that I consider. And we want to make sure that whoever is kind of inheriting those rights are eligible to do so. And if some reason they're no longer eligible, we want to make sure that there's other beneficiaries that might be eligible that are listed there just in case. So yeah, it's a little bit more of a complicated process just because, like I said, there's different rules that apply to First Nations and all bands will have different property policies.
Mhm. Makes sense. Just before we move on, we have a lot of questions coming in through the chat. Please keep asking questions, but we will get to them at the end of our webinar.
I'll also add too, so it's very important even, for First Nations to make sure that they're still having a will, because you can still, gift those First Nation rights to somebody else and they can receive them as long as they're qualified to inherit. But also your other personal property still has, meaning, and you need to distribute it. So bank accounts, if you have special sentimental family items that you want to gift, it's all important to capture those kind of things. The same goes for any Métis members. So there's actually different laws that apply to Métis individuals. So there's a certain form for Métis property. And again, we still want a general will that applies to all of their other things. So, bank accounts, special items, and those kind of things.
Thank you. So what if I own a property in joint tenancy with someone?
Yeah, that's kind of a hard question to answer because it is very complicated when you're owning property jointly with somebody else. I know a lot of people think it's great to own property jointly with somebody else because it can avoid, probate, and make it easier to transfer the property to somebody, but circumstances can be very tricky. So if you're owning property jointly with a spouse or partner, that's generally totally fine. Upon your death, title would be, transferred to your surviving spouse and partner, and they would just inherit it. It wouldn't flow as part of your estate. They just get rights as a surviving partner or spouse. So that's usually totally fine. But we do run into issues if you have a person who is owning property jointly with an adult child. That causes problems because legally the child can just say, my parents passed away, I'm the sole owner now. But there's actually a trust that applies to that property, and that property would still form part of the estate. So it's hard to kind of explain, and it really depends on circumstances, but jointly owning property is not always the easiest thing and very, often can lead to complications. So it's always good if you are owning property jointly with somebody other than your spouse, that you kind of get legal advice and make proper planning arrangements, and even sometimes address what your intentions are in your will.
Mhm.
Yeah.
Thank you. So then when and how should I update my will?
Yeah. So when you update your will, you have to follow the same rules that are in place for making a will in the first place. So if you want to, you can do what is known as a codicil, which is an amendment to your original will. So when you're doing a codicil, it still has to be made in the same fashion as like an original will would be done. So to make that amending will document known as a codicil, it can be, all written and typed up and signed by you in front of two witnesses. The other thing is you can also make an amending document known as a codicil in your own handwriting, so fully in your own handwriting, and then signed by yourself and dated. So you just want to make sure that you're still following the same procedures for making an original will if you want to change your document. Another option you do have too is to revoke a previous will and make a completely new one. So you can also do that, just making sure that you're following the requirements for making an original will. And when should you update your will? So, it really depends on your will document. When I meet with clients, I try to make sure that there's a lot of contingencies built in. So for example, appointing a personal representative, if they can't act, who would be next in place? If that person can't act, then who would be acting in their place? So just making sure that the document is very flexible depending on circumstances. But if you've given a specific gift to somebody, or you only have one executor or personal representative named, and that person passes away, that's a good time to update, your will document. Or other major life changes. So like a marriage, or, a divorce, or a death in your family, or a birth of children. So those are all kinds of major events where you'd want to look at updating your will.
Thank you. So what's the difference between a will, personal directive, and enduring power of attorney? We always hear these terms when we're creating a will. So would you please be able to elaborate on that?
Yeah. So again, a will is a written document that takes effect essentially when you pass away. So that's the instructions for, you've passed away, who's managing your estate and who's inheriting your estate. But I know there's typically a lot of focus on your will, but the other two documents in Alberta that are equally, if not more important, are your enduring power of attorney and personal directive. So these documents are incredibly important because they help to provide for your care while you're still living, but you just don't have the capacity to make your own decisions. So an enduring power of attorney is one of those documents where you can appoint a person to manage your financial affairs if you're too sick or too ill and lack capacity to make those decisions for yourself. So it's appointing somebody known as an attorney to step into your shoes and to manage your finances for you. They can, make sure that your bills are paid, make sure if you have investments, those are still going. If you have property, making sure your property is protected, insured, or sold, if that would be best for you. So again, it's just having somebody to step into your shoes and manage your finances for your best interest if you're too sick and can't do so yourself. The other document is known as a personal directive. So this is a little bit similar. So you're appointing somebody, but in this case, it's somebody to make your personal decisions for you if you're too sick and cannot do so yourself. So mostly this document would cover your medical decisions. So, treatments, what hospital you're at, and just medical decisions. So what are we going to do? So a doctor would look to that person who's named as your agent to make those decisions for you. A personal directive can also include things such as guardianship. So if you do have minor children in your care and their other legal guardian isn't in the picture or can't act for them, you can also appoint alternate guardians as well. So that's something that's important to do. And again, I should mention as well, your will could also have guardianship clauses. So if you're not able to, act as guardian for your children and your spouse has predeceased you or isn't there, you can also appoint guardians in your will as well. So it's very important if you have minor children in your care to make sure that you have those documents drafted properly.
And do you recommend creating these while you're creating your will, or is it
Yeah,
earlier,
so
later?
yeah, no, absolutely. So typically the best time is to get these all done together. So you can give instructions to your lawyer on what you want to do all at once, and then come in and sign all of your documents all at once. So, when I'm doing estate planning, our standard package would be to include all three documents at once because they're all very important, but they do different things. So it's important to have all three done.
Perfect. Thank you. So who can be a personal representative?
Yeah. So in Alberta, a personal representative has to be the age of majority in order to act. So that means here they have to be at least 18 years of age. Um, and it's always best for the person that you're appointing to be a resident in Alberta. If you're appointing somebody outside of Alberta, it can cause a little bit more complications. So it's always best whoever you're naming is an Alberta resident. Sometimes you can certainly name people jointly if you'd like. So have an Alberta resident and somebody else who's resident in Canada, they can act together. The problem you really want to avoid excuse me, is appointing somebody outside the country of Canada. So if you have a personal representative who is outside of Canada, that can cause a whole mess in terms of taxes that are applying, different rules that apply. So you want to really avoid that as much as you can.
So then what if no one wants to be my personal representative? What happens then?
Yeah, that can always be really tough. A personal representative should be somebody that you trust to act for you and, distribute your estate how you want to. But sometimes it can be very difficult to find persons to do that for you. But there are other options out there. A lot of banks will have corporate executors, so bank representatives will actually have executor services. Some professional executors can be out there. They're professionals that will do executor services for you if you don't have anybody. You can also look at the Public Trustee of Alberta. So in the event that there's nobody to act for a particular person, sometimes they will also agree to be an executor.
Mhm.
So it can be tough for some people for sure, but there are options out there.
And what are my personal representative's main responsibilities?
Yeah. So when you're appointing somebody as your personal representative, there are a bunch of things that they need to take care of. So the first thing that basically they're going to need to do is just make sure funeral arrangements are done. So, if it's burial or cremation, and making arrangements for, the proper treatment of your body. After that, they need to they're going to assess what kind of assets exist and debts. And they need to make sure that all of your debts and liabilities are paid first from your estate assets. So any debts or loans, credit cards, for example, mortgages, and they have to make sure your taxes are filed and all outstanding taxes are paid. So they have to make sure that all debts and, all of those kind of liabilities are paid first. In terms of your assets that you have, so if you have a house or car or whatever, they do need to make sure that they're protecting those assets. So if you have a house, they have to make sure that it's insured and somebody's checking on it. So they're going to hold and protect. And if there's bank accounts, invest estate property until such time that all of your debts and liabilities have been paid and it's time to distribute property to beneficiaries. Another thing that a lot of personal representatives don't know is they do have to keep records of what they're doing. So if they're making expenditures or paying for funeral expenses, they do have to make sure that they're tracking that and keeping receipts. So they just have to make sure that they're keeping, those kind of records because beneficiaries, residual beneficiaries are entitled to see those kind of records. And then lastly, when everything's kind of wound up and they're ready to distribute, they're going to distribute property and the estate residue to the beneficiaries who are entitled as per the terms of your will.
Thank you. Looks like they have a lot of responsibility.
Yeah, there's a lot of responsibility. So, it's when I work with executors, I make sure that they know all of their obligations and kind of help them navigate that and make sure that they're doing the right things because there's a lot of obligations on them for sure.
Oh, good. What is a grant probate and why does a person represent need one?
So a grant of probate is a court order. When you have a will in an estate, what you do is you apply to court and submit the original will for what's known as a grant of probate. So the grant of probate itself is just actually a court order. It's certifying that the applicant who's applying they are entitled to be the personal representative of the estate. And it's kind of a certification that the court has the will, there's no concern surrounding the will that they can see, and that this is the last will being submitted for probate. So basically, it's a court order. Reasons why you might need one, you don't always need one, but if a deceased person in Alberta has real property, so real estate that's just solely in their name, in order for anybody to deal with that, land titles does have a requirement that a grant of probate is required first before a personal representative can deal with land. So even if somebody is in tenants in common or they own mine and minerals solely in their name or other kind of property solely in their name, that's real property, then a grant of probate is an absolute requirement. Sometimes it also depends on other assets that a deceased person has left. So when you're dealing with banks, a lot of banks will have internal policies and they're like, you know what, if we have money over a certain threshold, we're going to need to see a grant just to make sure that, everything is good to go and just to make sure that they're releasing it to the properly named personal representative. So sometimes it'll depend on the banks too. If you have a spouse, for example, and everything's held jointly and things are just going to your spouse because they're the surviving joint owner, then sometimes probate's not needed. So really the big question is what kind of assets do we have? And is a grant of probate going to be required? In some instances too, if you have a lot of beneficiaries and you might think, well, there's possible that they could fight about the will. Or if you have people that might have strong claims against the estate, then sometimes it's also good to get an official grant of probate done as well.
Thank you for that. And what are some reasons someone might challenge my will?
Yeah. So a person could challenge your will. But there's all kinds of reasons. Some of the main reasons are if they don't like how your will is made and they think when you made it, you didn't have capacity to understand what you're doing. So there can be quite a lot of capacity challenges made against a person's will. So if they think this person had no idea what they were signing, they would never do this, and there's medical factors or capacity issues, a will could be challenged based on capacity grounds. Another reason is if a person suspects a person made a will, but they were really forced into doing it by somebody else, or they were really strongly influenced, and that if this person wasn't influenced, they would never have made this kind of will. So that's known as undue influence. So that can also be a ground for challenging the validity of a will. Another way of challenging a will would be, again, if you're not leaving adequate provisions and support for people who are dependent on you. So that would be your spouse, an adult interdependent partner, minor children, or any adult children if they're not able to earn their own livelihood or they're going to school full time. So all of those kind of dependent people, if you don't adequately provide for them, they could make a challenge against your estate for more support. So there's lots of different challenges out there.
And what is the role of the Office of the Public Guardian and Trustee when it comes to wills?
Yeah, so the Office of the Public Guardian and Trustee, what they will do is they're definitely they're more involved if there's an estate administration going on and there are minors involved in the estate. So if there's any gifts being made to minors, if there's any minors that might have, a challenge against the estate for more support, then the public trustee will be more involved in monitoring and making sure that those minor children are, provided for, or that property going to the minor is being held for them properly. So the public trustee can also act as a trustee if there's a gift being given to a minor person and there's no other trustee appointed in the will to hold that until the minor child attains the age of majority. So if you're giving a gift to a grandchild or something for that, for as an example, but you pass away and they're not 18 when they're entitled to inherit that gift, and there's no trustee appointed in your will, the public trustee is the automatic trustee of that property for that minor until they turn 18. So there's again a lot of complications and considerations that go into making your will. So if there's minors that are going to inherit, it's definitely something we want to look at. And we want to make sure that there's a proper trustee clause just in case there's any minor beneficiaries in your estate plan.
Thank you. So it looks like we're at the end of our questions. And so what else would you like to know? Please submit your questions using the Q&A function below. We do have a lot of questions in the chat already.
Let's see. Okay, so I can just kind of start going through some of these.
Yeah, go ahead. Yeah.
Yeah. So this person says, my situation is very simple. Can I use one of those will kits? So I know a lot of people will think that their situation is simple, and sometimes it is, but depending on the assets you have, your family structure, there could be things that you're just not aware of. So, well, you can use your will kit. It's just kind of, at your, at your own option. Having, a lawyer assist you with this, I've seen all kinds of different circumstances and like different options that I can suggest to somebody, and I'll take a look at your assets and what kind of property you own and make suggestions or trouble spot issues. So you definitely can use a will kit, but again, lawyers can sometimes offer you other insights or advice or options. And also when you do meet with a lawyer, they'll make sure that your will is signed properly because there's very technical requirements. You need to have certain witnesses. There's a requirement for witnesses to, be, not named as a beneficiary or as an executor. So you're going to need to have two neutral witnesses. And then you also need a commissioner to sign that affidavit. So for a lot of people, that can be a lot to juggle. So while you can certainly do it, if there's any mistake or you miss something in your will, or if you don't sign it properly, it can cause problems down the road and require applications to fix it or to get advice from the court. So you can, but again, when you hire lawyers to assist you with that, we do make sure everything's done properly. Okay. Okay, so there's a question here that I do have this person has their original will. The lawyer that prepared it has now passed away. Is this a problem during the probate process? So no, it's not a problem. You've signed your will, that's your legal document. The only other thing that could cause a complication is you need to look to see if that lawyer who prepared your will signed that, witness affidavit. So again, you're always going to have two witnesses on a will. One of them needs to sign an affidavit that goes along with your will when it gets submitted for probate. So I'd say just double check if the lawyer hasn't signed it. You can always try to track down the other witness. And if you absolutely can't find either of the witnesses anymore, you can always just let the court know this and have somebody else kind of sign an affidavit that just kind of confirms this looks like your signature. So it can be a little bit trickier if that affidavit of witness is not attached. But generally it's not a problem, but look for that affidavit. Let's see here. If people are separated, not legally, but just living separate and one partner dies, does this change if there's a will or not? So that, it really depends on the nature of the relationship to start and how long you've been separated. So generally, if you've been separated for 2 years or more, there can be disentitlements, in a will or under intestacy provisions. So when a person dies without a will, but again, that's a very tricky question. So it's hard for me just to give an answer without having the full understanding of what the relationship was like and how the parties are living separate and apart. Somebody writes, I have accounts with 2 banks. So what happens when I pass away? So again, those bank accounts will form part of your estate. So again, if you have a will, you're going to have your executor named, and that person will be able to kind of access and manage those accounts and distribute it in accordance with your will. If you don't have a will, somebody who has priority to administer your estate is going to have to step up, apply for a grant of administration, and then try to get a court of administration grant in order to access the bank accounts. So having a will makes the process much more quicker. Sorry, my throat's getting dry because I've just been talking. But again, it forms part of your estate. So if you have a will, the executor will get access to those bank accounts and they'll use it to pay your debts and all that kind of stuff. And if there's money left over, they'll distribute it as per your will instructions. If there isn't, then you're under the intestacy provisions. The bank will most likely not let anybody access it until there's a grant of administration that appoints a person who has the legal right to access those accounts on behalf of the estate. And then those bank accounts would just be dealt with under the intestacy provisions. Again, debts would still have to be paid first, and then distributions would be made to people who are entitled to inherit under the Wills and Succession Act. Share information about the charitable benefits of giving through one's estate. So if there's bequests, stocks, life insurance, and so forth. And the importance of letting a charity know about your plans. Charity bequests can be quite a strong tool to assist you in lessening your tax obligation when you pass away. So it's definitely something that can be looked at, and a lot of people do like to make charity gifts. So I think it's important. When I'm working with clients, we always want to make sure that we're identifying the proper charity. And the Government of Canada has a really nice search tool where you can see the charity's legal name and along with their charity registration number. So we want to make sure that they're actually a legitimate charity. And certainly you can leave gifts to them. You can leave, cash amounts to them. You can leave part of the residue. If you're dealing with something a little bit trickier, like stocks or property, that's a little bit more involved. In that case, it's good to reach out to the charity. Would they be in a position to accept this kind of gift? We'd have to do a little bit more investigating, but it can be a very strong tool to reduce taxes upon your passing for your estate for sure. Okay, let's see. Assets in a foreign country that aren't property. So for example, a retirement investment account. So a retirement investment account. So again, that foreign country is going to have its own rules about wills and who's entitled to benefit from those kind of, types of property when somebody passes away. So, we have such a vast world and there's, every country is going to have its own rules. So if somebody has something like that, it's like my recommendation, you need to go speak to a lawyer in that jurisdiction to kind of see how to properly deal with it. If you have a will, who's entitled to inherit, who can you give it to and how do you make a will properly in that jurisdiction to deal with that property? And if you die there without having a will, what would happen to that property under their intestacy provisions? So again, it really depends on the country because every country is going to have different rules. Is there a customary honorarium for an executor? So executors, under Alberta law, they are acting as trustees. They're entrusted with property and they have to manage it, and they're under very strict conditions with respect to managing it properly. So because they're acting as a trustee, they are entitled to compensation for their efforts to manage and wind up your estate. There are different ways to approach compensation. There's no hard and determined amount, but compensation has to be reasonable. So sometimes, it can be a good idea to use a percentage of the estate. So, say anywhere from 2 to 5% of the value of your estate, and then anything else coming in, they'd be entitled to a percentage of that. So you can set percentages. Other ways of dealing with compensation, you can kind of set a flat fee. Depending on how much property and work you think they're going to do, you can say 2,000 or 5,000. But if it turns out to be more work, they can get a higher amount approved either by the court or the residual beneficiaries. Sometimes people are like, you know what, I don't have a lot in my estate, but because of circumstances, it is going to take a lot of time to kind of wrap this up. So let's go with an hourly rate. So of course you want to at least do minimum wage. So some people will say the minimum wage in effect or minimum wage plus $2 or $5 or whatever. And then the trustee can just make, records of, their hourly time spent on administration tasks. So a lot of times too, if you have family members who are acting like a spouse or a child, they can also waive their right to compensation. So a lot of executors choose to do so, but they don't have to. They are, as a standing point, entitled to compensation for their efforts because it does take time. Another thing executors are definitely entitled to is just to reimburse themselves for their out-of-pocket costs. So if they're driving downtown to meet with a lawyer or an accountant and they're incurring parking, they have to drive around and they're expending a lot of mileage, they're allowed to reimburse themselves for those kind of costs. Do you have to list insurance policies in a will, or are they separate and are direct benefits? So depends on your insurance policy. So you can have an insurance policy. Most life insurance policies will allow you to designate a beneficiary directly on that insurance policy. So if you have an insurance policy and you write a formal declaration with your insurance provider and you say, I want this paid directly to my spouse, that insurance policy will go to your spouse. It stays out of the estate, it goes to your spouse. You can say on your insurance policy, I want it paid to my estate. So if you have your estate designated or if you have no designation at all, it will go to your estate and be dealt with as part of your estate. You are actually also able to make beneficiary designations of insurance policies directly in your will. But if it's a simple designation, it's always good just to do it directly with your insurance provider, just so that they don't miss something in your will. It's good to keep that up to date with the insurance policy itself. Can my personal representative live outside of Canada? So again, the problem with executors that are outside of Canada is there's going to be tax complications, because for taxation purposes, the government looks at residency. So if you're naming somebody in the United States, for example, and that person lives in the United States, they're going to have US tax reporting obligations as well as Canadian tax obligation reporting. And a lot of the times that can get very confusing, very complicated for your state, very costly, and it can result in taxes in that foreign jurisdiction and also in Canada. So there can be like double taxation, well, not double, but extra taxation that occurs. So it's always the very best policy to appoint somebody in Alberta, and if you can, and failing that, have somebody within Canada. One thing that you can do is have joint people. So if you do want a foreign person involved, you can appoint that foreign person jointly with somebody who's in Alberta, preferably, or within Canada, and then they can jointly act. But yeah, there's tax complications, and you still have to be very careful when it comes to managing that kind of estate when you have an executor that's outside of Canada. Okay, what happens to kids when both parents die? So who will get custody? Is there any need for a will? So in your will, you can have what is known as a guardianship clause. So that says, if I pass away and my minor children have no other living legal guardian, I'm appointing these people to be the guardian of my minor children. So absolutely, for any parent, it's important to put that in your will. Sometimes the case can be, spouses often do things together, travel together. So if they pass away at the same time, you want to make sure that those guardianship clauses are in your will. So there's certainty. You generally have conversations beforehand with these proposed guardians so that they are aware of this, and your guardians are appointed. And that's it. I mean, it's in your will, you're appointing the guardians. If there is no guardian appointed, and you pass away, there's minor children in your care and you don't have a guardian, then another formal court process has to be done, which is an application of a guardianship. So that is a whole other separate guardianship process. So somebody would have to apply. There can be contention who's the best guardian. People can fight over guardianship. So will makes your directions more clear and appoints that alternate guardian without the need for any, contention or additional court orders. Can executors live in a different province than me? Like I've explained, yes, they can. It's best to have somebody within Alberta. If you have somebody outside the province of Alberta within Canada, what that means is that an Alberta judge is going to ask for a bond for an executor that is outside of Alberta. It's just an insurance policy, and it just protects the value of your estate for the benefit of beneficiaries. If you, best case, appoint somebody in Alberta who would also act jointly with somebody outside of Alberta, but within Canada, that would be enough to get around that bond requirement. But again, your best bet is always use somebody in Alberta if you can, but you can certainly appoint somebody outside of Alberta if that would be the best option. There just would likely be more costs and administration matters to take care of if they're outside of the province.
Harry, we'll take two more questions and then
Sure.
wrap it up.
Yeah, time does fly.
Yeah.
There are a ton of questions here. So if I don't get to your questions, feel free to reach out if you'd like some more information. Again, my name is Sherry Simons. I work at Witten Law. You can Google my name and find my email address if you'd like additional information. Just a quick one is a personal representative, a new name for an executor. So an executor is more of a traditional name for somebody appointed in your will. Personal representative is being used now in current legislation just to cover whoever is managing the estate. So it can refer to an executor named in a will, or somebody who applies and gets a grant of administration to act. So personal representative is just kind of a global term for the manager of an estate. Canadian property. So if you have property in Canada and there's no surviving spouse or beneficiaries in Canada, can it go to a family member outside of Canada? That is a tricky question. So it depends on the property. Right now, there are rules in place against, ownership of property by foreign people who live outside of Canada. There's also in Alberta restrictions on farmland. So it really depends on the property that you're trying to gift and the qualifications of that foreign person. So if there are restrictions, again, we got to look at the property and look at what the restrictions are. If they aren't entitled to, inherit that particular property, then your estate administrator would have to sell it instead. And the proceeds of the sale could go to that person. So it can be tricky for sure. Okay, so that counts as our two questions.
Yeah, it does. If you maybe another one if you would like.
Okay. Okay, I'll do so one more here. If a holographic will is scanned and stored digitally, would this still be recognized? So right now in Alberta, we don't recognize digital wills. So you can certainly take a scan of your holographic will for safekeeping, but for the probate purpose, we have to submit that original holographic will. So it's important that you let your executor know where that original can be found. If that holographic will cannot be found, there can be applications made to try to validate the copy, but you'd have to bring a lot of evidence to kind of prove that, there's no circumstances where you think it might have been revoked, and it does involve a whole other court application. So that can be tricky. You always want to maintain the original will because the original will has to be submitted to court as part of the probate process.
Just another question I've seen in a few actually.
Yeah, absolutely.
Do handwritten wills require a witness of signing? There's actually a few questions about the same
Yeah,
topic.
okay. So the handwritten will is the holograph will. So no, you don't have to have any witnesses. But again, you just want to make sure that it is made exactly in accordance with the requirements under the Wills and Succession Act for holographic. So holographic means it has to be in the person's own handwriting. So you have to handwrite out the entire thing, sign it, make sure it's dated. So it has to be completely in handwriting, in your own handwriting, or in order
Mm,
for it to be valid.
okay.
Yeah.
Well, no, thank you for that. And then if we move on here, like we said, let's stay connected. Please find us online and on social media. You can also subscribe to our monthly e-newsletter to get the latest updates in the law and our resources. After you log out from Zoom, please take 30 seconds to complete our survey and let us know how we did today. There's a link in the chat for our survey, and there'll also be a link on your browser page when you exit. Thank you for coming today and thank you for joining. Again, thank you, Sherry, for helping us out and answering some questions today on about wills.
Yeah.
And yeah, thank you very much.
Yeah. Thanks, everyone. And contact me if you have more questions.